Court is now in session. Please be seated.
Good morning. Introductions, please. Mr. Nakbar.
Yes, good morning, Your Honor, and all Your Honors. Kenneth Nakbar, Morris Nichols, Arshton Tunnel, here on behalf of CRODA, Inc. With me today at council table is David Cooper of Quinn Emanuel or Cardin Sullivan, who will be arguing on our client's behalf. Also with us today from Quinn Emanuel are Michelle Schmidt and Athena Dalton. And finally, from CRODA, Inc., Senior Corporate Counsel, Christina Manueli.
Welcome, everyone.
Thank you.
All right, before you get started, so I looked at the putative class residency that was attached to the in the complaint, and I wanted to make sure that I was not a member of a possible member of the class, and my understanding is that I am not, but I do live close to it. But I just wanted to make that clear for everyone, at least as I have determined that I am not a possible member of the class that's here. And if anybody has an issue with that, they can bring it to my attention, but I'm satisfied that I don't have any issue. So, thank you.
May I begin?
Yes.
Good morning, Your Honors. May it please the Court. Christine McIntosh from Grant & Eisenhofer on behalf of Plaintiff Catherine Baker in the putative class. I'm joined at council table by my partner, Kelly Tucker, and in the gallery is my partner, Adam Gomez. We're here today on a certified question from the United States Court of Appeals for the Third Circuit. The issue the court must decide today is whether Delaware law should recognize that an individual who has been exposed to a toxic carcinogenic substance as a result of another person's misconduct has suffered a compensable injury where that person, one, faces a substantially heightened risk of developing cancer, and two, has a present need to undergo costly and invasive medical testing to ensure early detection of that disease. The specific question the Third Circuit has certified is as follows: whether an increased risk of illness without present manifestation of a physical harm is a cognizable injury under Delaware law. We respectfully submit that the answer should be a resounding yes. I'm going to explain why both Delaware law and public policy support answering the certified question in the affirmative. But before we get there, let's take a step back and talk about what this underlying case is about. CRODA is an $8.5 billion United Kingdom corporation. Its United States subsidiary owns and operates the Atlas Point manufacturing plant up the road in Newcastle. In the course of its operations at this plant, every year, CRODA produces up to 30,000 metric tons of ethylene oxide. Now, what is ethylene oxide? It is a highly toxic, mutagenic chemical that causes cancer. And each year, CRODA releases massive amounts of this toxin into the air, where it lingers at breathing levels for months due to its 211-day half-life, half-life. CRODA has repeatedly violated environmental regulations in its emissions of ethylene oxide, including most notably a massive accident in 2018 in which CRODA released 2,688 pounds of ethylene oxide into the air, forcing Delaware residents to shelter in place in their homes and shutting down the Delaware Memorial Bridge for about 7 hours. CRODA's emissions of ethylene oxide have imposed real and potentially devastating consequences on the Delawareans who live near the Atlas Point plant. By the EPA's estimate, these residents are up to 4 times more likely than the average American to develop cancer due to their exposure to ethylene oxide. The EPA's National Air Toxics Assessment ranks the cancer risk for the Delawareans near that plant as the highest in the state of Delaware and among the highest in the entire country. Now, medical tests exist that would allow the Delaware residents that CRODA has exposed to a heightened risk of cancer to get diagnosed at the earliest possible opportunity. And plaintiffs want CRODA to pay for those tests. But CRODA asks this court to find that it doesn't have to do anything at all to help these Delaware residents because, according to them, CRODA's release of a lethal carcinogen hasn't injured plaintiffs and her neighbors because they don't have cancer yet. The fact that plaintiff and the other Delaware residents who live near the Atlas Point plant are at a significantly increased risk of getting cancer and are now subject to an immediate need to have medical monitoring to detect cancer at the earliest date by CRODA's lights is simply irrelevant for present purposes because according to CRODA, Delaware law doesn't recognize this harm as a redressable injury. CRODA is simply wrong. We respectfully submit that both Delaware law and public policy support the remedy plaintiffs seek. First, let's talk about...
Could I just stop you for
Sure.
a second and ask you how you determined who should be subject to medical monitoring in the future?
So that is something that, if the case gets over a motion to dismiss, we would need expert testimony for a physician to determine that medical monitoring exists, that it would be beneficial, and that specific residents have a need for that medical monitoring.
Well, I know, but the complaint has an area that it defined, but what, and I think this is relevant to what we're trying to decide, and that is how wide is the net cast for the plaintiffs? Is it everyone in the state of Delaware? Is it Newcastle County? Is it the residents surrounding the plant? And that kind of leads into the public policy decision that we're considering here, and that is, you know, where is the end of this? And how did you draw the lines for this case, and maybe the lines should be different?
It is my understanding that the census tracts were selected based on the EPA's estimate of which areas were most likely to be substantially impacted by the release of ethylene oxide. That's my understanding. All right, let's
I'd like
talk.
to follow up a related question
Sure.
while we're talking about that, and it goes back to one of the policy concerns Justice Breyer raised in the Metro North case, and that is the difficulty in determining how much monitoring is extra monitoring, that is, people monitor their medical health and their cancer risks without having been exposed. That poses a practical problem, and as much as we're dealing with policy issues here, I think it's appropriate to ask about that. What's the framework that you envision for determining what medical monitoring is related to the exposure as opposed to normal medical
So
monitoring?
I envision the framework to be the same framework that courts like New Jersey have adopted in these types of cases. Plaintiffs would need to prove by competent expert evidence that they have an exposure to a proven hazardous substance, that specific plaintiff suffers a significantly increased risk of contracting a serious latent disease as a result of that exposure, that a reasonable physician would prescribe a monitoring program that is different than what they would have prescribed in the absence of that exposure, and that there are monitoring tests available that exist that would actually make early detection possible and beneficial. So I believe that would be the appropriate framework. But before we get to the framework, we need to discuss whether Delaware law recognizes this remedy. And I respectfully submit that allowing plaintiffs to recover for the cost of medical monitoring is entirely consistent with Delaware law. 28 years ago, in Broska v. Olson, this court adopted an actual exposure to disease-causing agent test that we submit strongly recognizes a claim for medical monitoring for people like the plaintiffs who have actually been exposed to a known carcinogen.
But that was the dentist case, right, that you're referring to, where
Yes.
patients were exposed by the dentist who had contracted AIDS, right?
So here's the thing. In Broska, the plaintiffs were asking for recovery for fear of AIDS because they had been treated by a dentist who had HIV. And the court said, well, no, you haven't proven that you were actually exposed to HIV. And in the absence of proof of exposure, there shouldn't be a claim for fear of disease. Now, what we have here are plaintiffs that will be able to prove that they were actually exposed, and they're not asking for something sort of amorphous and, unconcrete as fear of disease. They're asking for a concrete remedy of recovery of the quantifiable cost of monitoring that is medically necessary to detect the lethal disease that they are now at a heightened risk of contracting due to CRODA's emissions of ethylene oxide.
Ms. McIntosh, while you're on Broska, I understood the court's focus on actual exposure to be in connection with the battery claim, but was qualified by a statement that plaintiffs have sustained no physical injury and therefore they could not recover under a negligence theory. Why doesn't that undermine your argument that all a plaintiff needs to show is exposure?
Because in battery, by definition, you need to have an offensive touching. And here, there's not a requirement for a negligence claim, for a strict liability claim, or for the other claims that are asserted in our complaint that there has to be an offensive touching. And I think the relevant question is whether the plaintiffs have suffered an identifiable harm. And we respectfully submit that despite the lack of a physical harm, under Delaware law's adoption of the restatement, recovery can lie for injury, for harm, or for physical harm.
Well, my question is, doesn't Broska say that in the absence of physical injury, a negligence action will not lie for mental anguish?
No, I don't believe that's what it says. And again, Your Honor, here respectfully, we are not seeking a claim for mental anguish, which a mental anguish claim by definition requires physical contact. The court hasn't ruled that a claim for heightened risk or medical monitoring requires a physical impact, and we respectfully think that it shouldn't. If Delaware law would allow a plaintiff who was treated by a dentist to recover for something as vague as fear of AIDS, we respectfully submit that it absolutely should allow a plaintiff who was actually exposed to a toxic substance by a multi-billion-dollar corporation and who has now suffered a quantifiable risk of increased cancer and has a present actual need to spend money on medical monitoring should be allowed to recover. I think that there's different policy considerations, and I think that we're on the right side of this particular issue.
Ms. McIntosh, if the court were to adopt your view, what effect would it have on our jurisprudence with respect to the statute of limitations? That is, as I understand it, currently the statute of limitations begins to run when an injured person feels the physical effects. If there are no physical effects, but we're nevertheless saying there is a claim here, does that mean that later on, to the extent somebody actually has one of these diseases, the statute has run?
No, I think there's two separate injuries here. And when you look at what this court did in Anderson, it recognized that there's a difference between where the damage is the increased risk and where the damage is the resulting harm. And here, the plaintiffs know now that they are at increased risk, and they know right now that they need to recover medical monitoring. So I think it's appropriate to allow the statute of limitations on those claims to run. And they're not seeking here to recover for the actual cancer that they might get down the road. They're seeking to recover for the need they have right now to seek medical monitoring to allow them to get treatment in time for it to make a difference. So I think that's the difference.
So you're envisioning sort of serial claims where there's claims now and claims later?
I think there's different injuries. There's a claim for the injury, which is the heightened risk and the medical monitoring, and then there could be a different claim down the road when they actually got cancer. But I think respectfully, the issue right now is there a claim for medical monitoring? And I think that under existing Delaware law, there should be. And I think United States versus Anderson also supports our argument. There, the court was asked to decide whether an increased risk of harm following a failure to diagnose cancer was compensable. And in ruling that increased risk was compensable, the court noted as follows: compensating a tort victim for an increased risk which results from some harm caused by a tortfeasor fits comfortably within traditional damage calculation methods. The court didn't hold that compensation for increased risk was appropriate only if it resulted from physical harm. It said it was compensable if it resulted from some harm. And the plaintiffs here have suffered harm. If you look at Justice Ginsburg's dissent in the Buckley case, she notes a plaintiff seeking recovery of medical monitoring in the absence of an injury has suffered injury, namely the invasion of the interest in being free from the economic burden of extraordinary medical surveillance. And while defendants assert that Anderson forecloses recovery for medical monitoring absent present physical injury, they're simply wrong. As an initial matter, Anderson didn't involve a claim for medical monitoring at all. And it didn't address any issues relating to recovery in the unique context of latent disease caused by exposure to a toxic substance. The issue in Anderson was whether a plaintiff in a federal tort claims action could recover for increased risk of recurrence of cancer following a government doctor's failure to diagnose. And the court held that a plaintiff who had stated a claim under Delaware's medical malpractice statute could also recover for increased risk. But the court expressly declined to reach the issue of whether a plaintiff could bring an independent action for increased risk. And the court statement on page 74 of Anderson that increased risk of harm accompanied by physical injury is compensable respectfully doesn't answer the question today. The court didn't say that it was compensable only if there was also an accompanying physical injury, and the court's use of the accompanied by physical injury language reflected the reality that the court there was limiting its holding to whether increased risk could be recovered by a plaintiff who had already stated a medical negligence claim. Defendant citation to page 77 of Anderson, where the court was discussing Connecticut law's adoption of the increased risk doctrine, is also unavailing on the issue here. The Connecticut court had adopted a version of the increased risk doctrine under which a plaintiff who sustained a present injury could also recover for increased risk without showing that the future event was more likely than not to occur. And in discussing the Connecticut court's holding, the court in Anderson simply noted that requiring physical harm in the context of the increased risk doctrine addresses concerns about speculative claims for future harm. The court didn't endorse this approach in any way, let alone adopt it as Delaware law. And leaving aside the Anderson dicta, Anderson supports plaintiffs and refutes defendants in a number of ways. First, the court drew a distinction between seeking recovery for increased risk and seeking recovery for the resulting harm. And the court noted that the increased risk, quote, should be viewed as an injury and compensable. That's at page 78. And second, the court noted that where the claimed injury is the increased risk and not the ultimate result, it makes no sense to force a plaintiff to wait for the ultimate result to materialize to file an action. On page 76, the court said, if the injury is the increased risk or loss of chance and not the ultimate result, however, it makes no sense to force plaintiff to wait for the unfavorable result. Yet that is exactly what the defendants would have the plaintiffs here do.
Mackenzie, I have a question, again, policy driven, regarding what limiting principles surround your proposed rule. Have you given that any thought? For instance, one thing comes to my mind is secondary tobacco smoke. Would that, if you're exposed to secondary tobacco smoke, some people, at least I've heard, say that you have an increased risk of developing some sort of lung disease and even cancer. Would that support a tort action in the absence of any physical harm?
No, I don't, and I think the court's decision in Mergenthaler sort of answers that question. In the Mergenthaler case, as your honors will recall, the issue was the wives of people who had worked with asbestos had laundered the clothes and they had a sort of indirect exposure to asbestos, and they were saying, we should be able to recover for mental anguish. And the court said, no, you need a direct exposure to the substance. So I think, that's the limiting principle. Is there a direct exposure? And I think in your secondhand tobacco analogy, I think that's distinguishable.
I'd like to go back to Justice LeGros' statute of limitations question. And for a medical monitoring claim like you're attempting to assert here, when does the statute begin to run?
When the plaintiff knows that they have been exposed to a toxic substance.
Well, as I understand your complaint, you say there's been an exposure over a period of time, and then you also isolate on the bridge incident, let's call it for want of a better description. So where in that continuum did the statute start to run for this plaintiff?
I think the statute starts to run when there's an exposure and when the plaintiff has reason to know that that exposure was caused by another person's misconduct and that exposure has placed them at an increased risk. I think you need to have those elements in order for there to be a claim.
Ms. McIntosh, you're talking about elements for a statute of limitations and elements for when there would actually be a claim for this medical monitoring. You referred to some of the elements that New Jersey courts require. At a certain point, doesn't this really become a legislative issue as opposed to a judicial issue? That is, if Delaware wants to recognize this as a claim for its citizens to make, isn't that really a decision that should be made by the legislature?
No, respectfully, I don't think so, because the particular issue here is what constitutes a compensable injury under Delaware law. And there's different issues. There's whether medical monitoring could be a pocket of damage that's recoverable on account of negligence or strict liability. And then there's also the separate issue of whether it's a freestanding cause of action. And for present purposes, whether it's a freestanding action or not, under the claims that we have asserted, we respectfully submit that at a minimum, it is a compensable pocket of harm flowing from the negligence, the strict liability, and the other claims that we've asserted. And I don't think that the absence of legislative action means that this court shouldn't rule on this question. And I think that it is within the court's equitable powers to craft a remedy for this.
So I just want to make sure, and I know you're in a rebuttal.
No, I'm into my
Are you saying that it's your prime position that this is an independent claim as opposed to a remedy?
Are you asking if it's my prime position that it's an independent claim?
Yeah.
My prime position is that it's compensable. Whether it's a pocket of damages that's recoverable as part of an existing tort action or an independent claim, either one, we respectfully submit that these plaintiffs win. We do think that there should be a separate claim, but the elements that you would need to prove in order for it to be recoverable, you end up proving another claim along the way. So I think respectfully, either way, this is something that we're on the right side here. I've noted I'm into my rebuttal. I had a lot of other points I wanted to make, but I think it's probably best for me to save the time for rebuttal.
Thank you very much.
Thank you.
Cooper?
Thank you, and may it please the court, David Cooper on behalf of defendant Appellee CRODA. Plaintiff represents a class of people who, by definition, have suffered no physical harm from the alleged exposure here. The question is whether they can state a claim based on the potential of future injury in the absence of that present harm. Now, it's well established and undisputed here that to state a tort claim, there must be an injury. What they've alleged here is speculation about future injury, and speculation is not an actual injury. As this court said in Anderson, as the U.S. Supreme Court said in the Metro North case, as many state Supreme Courts have recognized, there has to be some limit on claims based on potential future harm, and that limit is the existence of a present physical injury. We're all exposed every day, countless times, to things that can cause us harm in the future. That is simply the reality of the world that we live in. And that's why most courts that have considered this issue have recognized that the existence of a present physical injury is necessary to cabin those claims. If not, then courts are thrown into a morass of figuring out when is increased risk enough. What about how to deal with the difficult scientific questions about the nature of that risk? How to deal with the existence of other risks that interact with them? How to determine what medical monitoring is necessary? What medical monitoring is necessary over and above general medical monitoring that should be done anyway? And to do this all very frequently on a class-wide basis. And courts have recognized that this kind of enterprise is much better suited for the legislature than it is for the courts. And this case is the prototypical example of the problem. We have a class comprised of people who lived in a certain area, and as opposing counsel noted, they're living in a certain area. But what opposing counsel did not mention is anyone who lived in that area for at least 1 year over the last 35 years. So while there's discussion about this bridge incident, that is not the way that the class is framed or alleged. The alleged class is anyone who has lived in a certain area for at least 1 year over the last 35 years, even though they don't have any allegation that any of those people over the last 35 years has suffered any physical injury from the alleged exposure. The requirement of a present physical injury exists precisely to prevent these kinds of amorphous speculative claims, and that's why this court should reaffirm that requirement in this case. To talk briefly about this court's precedents, some of which were discussed by opposing counsel, I'd like to begin with the Anderson case. And the language that's particularly on point here is where this court said that increased risk of harm accompanied by physical injury is a compensable element of damages under Delaware law. Now, opposing counsel says, well, it doesn't say only accompanied by physical injury. I think that's parsing the language pretty finely and going beyond what this court actually held in that case. Beyond that, this court actually explains specifically why the requirement of present physical injury is necessary if you're going to allow future injury to become compensable without, and what this court said, this is page 77 of the Anderson opinion, is that to rein in the speculativeness, the requirement of a preceding physical injury ensures that the speculativeness does not go too far. And they say that that sentence is dicta, but it's in fact the reasoning of this court's opinion. This court in Anderson allowed potential future injury to be compensable only because it was recognizing that it was preventing that from becoming too speculative by also having the requirement of a physical injury. The Mergenthaler case is also very much on point. And the court stated that the question there was, quote, whether a claim for the expenses of medically required surveillance and related mental anguish of the plaintiff's wives fails to state a claim where there's no present physical injury, and we answer that question in the affirmative. Now, what opposing counsel suggests is, well, that dealt with indirect exposure rather than direct exposure. And first, as this court has noted, the discussion of indirect exposure in that case was in the battery context, not for the negligence claim. Nowhere in the discussion of negligence did this court say that the reasoning for this court's decision was based on whether the exposure was direct or indirect. I'd also note that in reference to Your Honor's secondhand smoke example, I simply don't see why that would be considered an indirect exposure as opposed to a direct one. If you are breathing in the smoke, I believe it would be very much direct to you and every bit as direct as breathing in ethylene oxide or any other chemical that happens to be in the air. But more importantly, it simply does not make sense to make direct versus indirect exposure the line here. So if exposure is indirect as opposed to direct, it may well be that you have a more difficult time factually proving that you face a greater risk of future injury. It may be, it may not be, but I can certainly see why it might factually be more difficult. But that does not at all answer the legal question, which is a very separate question of whether or not the existence of potential future injury, which was alleged in Mergenthaler, which is alleged here, constitutes an injury as a matter of law sufficient to state a claim. And on that issue, Mergenthaler is directly on point, and what it says is that as a matter of law, a potential future injury is not an injury that states a claim under Delaware law. The same is true of the Broska case. In the Broska case, this court said, quote, plaintiffs have sustained no physical injury and therefore they could not recover under a negligence theory. And again, opposing counsel says, well, in that case, the exposure was too questionable. It was dealt with the dentist who had AIDS, and it was obviously very speculative whether or not anyone would contract AIDS as a result of that dentist. But again, the question is not whether or not those people in fact had AIDS or whether those people had a certain degree of probability of having AIDS in the future. The question is whether, and that this court answered in that case, was whether or not the existence of that risk, whatever we think about the likelihood of that risk, whether the existence of that risk was sufficient to state a claim under Delaware law as constituting an injury. And in that case, this court said no. And the same, again, is true here. We can have debates factually about whether or not the risk was likely in Mergenthaler, whether it was likely in Broska, whether it is likely here. But that is a factual question. There's a legal predicate question, the question that this Third Circuit certified to this court, about whether or not potential of future injury suffices when there is no present physical injury. And the answer to that question in Anderson, in Broska, and Mergenthaler is no.
Where are we on the restatement?
Sure. So I think two things. First, there's the restatement second, there's the restatement third, which has not come out yet. So the restatement third is debating this question. It has not been decided and has not been issued in by the ALI for the restatement third. For the restatement second, the restatement second was issued in 1965. At that time, I'm not aware of any case in the history of the United States ever recognizing a claim for potential future harm. In fact, I think the first case I'm aware of is 1984. So in 1965, what the restatement said was, there has to be, said, injury is, quote, the invasion of any legally protected interest of another. It did not answer this question of whether or not that legally protected interest of another could include the potential for future injury. And it would be incredibly surprising to think that the restatement believed that, given that, again, I'm not aware of any cases in the 1960s, frankly, before 1984, ever recognizing the existence of a claim like that.
Mr. Cooper, you you frame this as a claim for potential future harm. The certified question speaks of increased risk of illness. And the assumption I make is that the increased risk of illness because of the exposure has been proved. Is there a distinction between proved increased risk and just a potential future harm, or is that just semantics?
I think, sir, I think in this case, at least, it is semantics. I think obviously they've alleged that they have an increased risk for the purposes of this appeal, and given where we are in the pleadings, we're not disputing that factually at this time. But ultimately, it comes down to the same thing. They are saying that in the future, at some point, they may have a higher probability of certain diseases, certain illnesses. And the same principle, the same idea was true in Mergenthaler, the same idea was true in Brusca, the same was true in Metro North, and in virtually all of the cases that we talk about from courts across the country. And so it's true that you can call it, you can use words to define it however you'd like in terms of whether it's increased risk of illness or potential of future illness. And we're not going to dispute factually whether that's the case. But the point is, and this is sort of the clause within the certified question, quote, without present manifestation of physical harm, that's really sort of the key question. If there's no manifestation of harm, but there is alleged a greater probability of harm in the future, you can call it increased risk, greater probability, greater possibility, whatever we want to call it, but the point is that nothing has happened yet. And the question is whether or not that states a claim, and that question, frankly, has been answered by this court in prior cases, and I believe those cases, regardless of this direct versus indirect issue, are very much on point.
What about Mrs. McIntosh's argument that there's a way to cabin this by applying what she recited as these 5 elements, I think it's 5, that other states have adopted?
Sure. So I think that there are a couple of problems with that idea. The first is that it's not as though every state has adopted the same test. She pointed to New Jersey. Previously in the reply brief, she pointed to, I believe, West Virginia. But if you look at this, the minority of states that have adopted this as a possibility, they are all over the map in what the test is. Some, for example, in Massachusetts require a subcellular injury. Some, like California, have a heightened standard for level of causation. Some, like West Virginia, have, I believe, a 7-part test. I believe she referred to a 4-part test in New Jersey. So suggesting that it's a simple matter of applying the test, I think, really minimizes the incredibly difficult task that would be before this court, or frankly, before other Delaware courts or federal courts trying to predict what this court would do in trying to define real limits, as must be done when the states that have tried to do so are completely all over the map. And I think it's worth looking at what the test is that they are advocating. The test that she talked about is whether someone has been, quote, significantly exposed. Very great questions. What is significant? To a proven hazardous substance. Unclear what the level of proof is. Increased risk of contacting a disease. Again, very difficult question about what that increased risk is. Whether tests are medically necessary. Again, enormously difficult questions, both as a scientific matter and as a legal matter, in applying those. And even when you get past the difficulty of formulating what the right test is, actually applying those tests in particular cases will be enormously difficult. So, for example, the opposing counsel mentioned, as part of the New Jersey test, that the specific plaintiff has an increased risk. Here we have a class of anyone who lived in an area for at least 1 year out of the last 35. The idea that we can determine as a scientific matter, and that courts can determine this, whether each of those people has an increased risk and what level of medical diagnosis and monitoring is necessary beyond what would otherwise be recommended for each of those individual people, I would submit is exactly why courts do not do this in the mine run cases.
Well, we're not. That's not before us. Whether the class is, whether there's a certifiable class, we've got to. Is that correct? We're to answer the question, and regardless of how it might work out for the class, isn't that correct?
That is correct. We're not asking this court to say whether or not the class is properly defined or could be certified as it's defined, but I think it goes to this larger question of the policy issue, because these are the kinds of claims that are brought when this kind of claim is permitted when there is, a departure from the traditional rule that allows the potential of future illness to be a sufficient injury to bring a claim. These are the kinds of claims that are brought, and these are the kinds of questions that courts have to deal with. And so while I certainly agree that this court does not have to decide anything about the merits of this particular case, I do think it's instructive, and I think it's telling as to the difficult questions that would face the Delaware courts if this kind of claim were permitted. And I think this also goes to this question of the statute of limitations, which Your Honor raised, and the question that was asked, which is, well, then would this create serial claims? And there's no question that it would create serial claims if the idea is that a person, even who was started to be exposed 35 years ago, can bring a claim at any time for monitoring, can bring a later claim when they potentially have future injury. And as many courts have recognized, we want to protect the people who ultimately will be injured if they have a legitimate basis for claiming their injury was caused by the misconduct. Those are the people who we want to ensure are compensated. And to, in the meantime, effectively prioritize and potentially use up all the money for people who suffered no physical injury would be a mistake. And that's what the court said in Metro North, what the New York Court of Appeals said in CRODA, what the Michigan court said in Henry. Repeatedly, again and again, they recognize that we have to look at the system as a whole and look at the benefits to the public as a whole, and not just look narrowly at this idea of should we compensate one person or more often a class of people for the potential for injury, as opposed to focusing on the people who actually have injuries that should be compensated if they can prove that they were caused by the defendant. So moving to what other courts have done as they've looked at this and the experience of other courts, I think the U.S. Supreme Court's reasoning in Metro North is very powerful here, and I'll note that it has been adopted by courts like CRODA, by courts like Henry, in very thorough, very well-reasoned decisions. And the three things that those courts tend to focus on are, one, the problem of unlimited and unpredictable liability. And that's because, as the Supreme Court has said, contacts, even extensive contacts with serious carcinogens, are common. That is the reality of the world we live in, and that is why there has to be a limit on these kinds of claims, and why courts have struggled to find them when they've allowed these kinds of claims. The second point, as I've mentioned before, is that you'd be potentially absorbing resources that would be much better brought to bear for people who actually suffer physical injury, as opposed to the kind of speculative claims that would be brought here. And the third is that, and this is in the Supreme Court's word, they quote, these kinds of claims would pose special difficulties for judges and juries, given uncertainty among medical professionals about these issues. Now, certainly there are difficult scientific questions, difficult medical questions in a lot of cases, but I think this goes beyond the norm of the difficulty that courts sometimes face in scientific or medical cases, because we're talking about not simply looking right now, for example, at whether someone who had the harm, whether that was caused by exposure, that can be difficult enough, but to look at what the likelihood of future harm is for an individual, let alone a class, then to try to extrapolate what kind of medical monitoring is needed for an individual and potentially a class, and whether or not that individual should have the medical monitoring anyway. These are enormously difficult questions for scientists, let alone for courts. And that is why the Supreme Court has recognized that opening up this kind of claim would be problematic. I'll note that opposing counsel's only response to the Metro North case that I saw in the reply brief was that, first, that involved an emotional distress claim. That is true, but it also involved a medical monitoring claim, and the idea about medical monitoring is replete throughout the Supreme Court's opinion. And the second is that it deals with the Federal Employers Liability Act, FELA. Again, also true and also besides the point, because as the Supreme Court reasoned through this issue, it did not base its reasoning on anything specific to FELA, and in fact looked at the common law, looked at what courts around the country were doing generally, looked at the experience and the difficulties of those courts, and then came to the conclusion that the claim would not be permitted. So there's nothing in the Supreme Court's opinion there that is specific to FELA or that would not apply equally to this court's determination here. Now, the majority of courts to consider this issue beyond the Supreme Court, and certainly the trend now is not to permit this kind of claim. And I know that there's been some numbers thrown around back and forth. What I would recommend to the court, if there's questions about how courts have dealt with this, is to look to the Barron's article that we cite in our brief. so that this court doesn't have to take our word for it, anyone else's word for it. It has a 50-state survey where it specifically says how every single state has come out on the issue with footnotes and citations to cases with parentheticals, exactly showing how the courts have come out on this issue. And by any measure, however you define the numbers, there's no question that the majority and the trend has been against recognizing these kinds of claims. The last point that I'll note is that if we look to the minority of courts that have allowed these kinds of claims, the problems that have arisen when they do so. And the first is that, as I've discussed before, there's a need to limit them in some way. No state simply allows the claims and then says, okay, anything goes. They have to find a way to try to limit them. But the ways in which they've tried to do so vary widely and are extraordinarily difficult and raise very serious policy questions that, again, are much better suited to the legislature. So, for example, heightened standards, whether for example, in California, in Maryland, the subcellular injury requirement in Maryland, 4-part test, 5-part test, 7-part test. And what the New York Court of Appeals said when they looked at this kind of, difficulty is that, quote, there is no framework concerning how such a medical monitoring program would be implemented and administered. And that is precisely the point. These courts are making up these tests basically from whole cloth. There's no tradition to them. There's no legal rule to rely on for them. They're simply things that the courts are making up in an effort to try to stem what would otherwise be an enormous flood of claims. And in doing so, they are taking on a legislative task that the courts should not be taking on, but also making it even more difficult for courts to actually apply the test. Because this questions about what a heightened pleading standard is, what subcellular injury is, what medical monitoring would be necessary. And another potential complication that, frankly, other courts have recognized is that if you're going to allow these kind of medical monitoring claims, you should have oversight over the medical monitoring to make sure that that's where the money goes and to figure out how much money is actually required for medical monitoring. On an individual basis, perhaps that would be simple. On a class-wide basis, it's often enormously complicated and requires constant court oversight dealing with very complicated medical and scientific issues. Now, if this court were to adopt one of these tests, and again, I've discussed what the sort of New Jersey test or the West Virginia test that's proposed in the reply brief would lead to in terms of the difficulty of those questions. But I think the example of West Virginia is a telling one, because as we cite in our brief, the moment that they opened up the door to these cases, there was a flood of these cases. And that's the reality of allowing a claim based on the potential for a future illness, given the exposure to substances that could, at least theoretically, or have a good faith basis for an allegation of a potential for future injury. So, and plaintiff does not propose any way to avoid this limitless litigation that West Virginia faced. No method for this court to determine what the test should be, aside from pointing to one state or another. And there should be an enormously high bar for creating what would essentially be a new cause of action in Delaware to recognize a claim in the absence of a present injury that this court and the legislature have never recognized. Plaintiffs fall very short of that high bar here. And if this court doesn't have any further questions.
Thank you very much.
Thank you, Your Honor.
Thank you, Your Honors. I'll be brief. Where to begin to respond to that? First, they keep pretending that we're talking about a speculative future harm. There is no speculative future harm. We are talking about the current existing up to 4-fold increase in the likelihood of getting cancer as a result of CRODA's emissions. And we're talking about the present real monetary cost of paying for the medical tests in time for people to seek treatment that actually could save their lives. So the notion that there's no, actual injury here is frankly outrageous. Second, the Buckley case, if you look at what the court actually held in Buckley, it was an extremely narrow holding. They want this court to think that Buckley held that full stop, if there's not present physical injury, there's no medical monitoring. That's not what Buckley held. Page 444, the court held, we do not find sufficient support in the common law for the unqualified rule of lump sum damages recovery that is at least arguably before us here. doesn't answer the question. Buckley is not dispositive of Delaware law. Third, I've heard a lot of, it's too hard. The courts can't figure this stuff out. Well, respectfully, equity is hard, and that's what this court does every day. And the fact that it might not be easy to come up with a one-size-fits-all solution is not a reason to deny the Delawareans that have actual present harm that has been caused to them by these people's emission of a toxic carcinogen, frankly, flies in the face of everything that we're doing here today. The notion that they need to wait until they have cancer because otherwise, CRODA might be bankrupt, that's outrageous. By the time some of these people, develop cancer, it's too late to get the medical monitoring. They need the remedy now to allow them to get the treatment that they need so they can potentially stem the tide from the bad things that these people have exposed them to. As for the floodgates of litigation, they point to one example that there have been some cases filed in West Virginia. Well, the fact that a remedy is created and people actually have the temerity to pursue that remedy doesn't prove that it opens the floodgates of baseless litigation. They haven't said anything at all about what happened in that West Virginia case, whether it was dismissed, whether it was some, massive onslaught. And I think these concerns are just, overwrought. Any doubts here should be resolved in favor of the innocent class members who, through no fault of their own, were exposed to a toxic chemical. And I just want to conclude, I think it's very interesting that they mentioned the Coronia case in New York. If you look at Chief Judge Lippman's dissenting opinion, he wrote the following: "Rarely are we presented with a case more worthy of the age-old maxim that equity will not suffer a wrong without a remedy. Whereas here it is within the court's power to provide a vehicle for plaintiffs to seek equitable relief capable of forestalling profound suffering and death, judicial hesitance and legislative deference only serve to thwart the ends of justice." Every single state with which the great state of Delaware shares a physical border recognizes claims for medical monitoring. New Jersey, Pennsylvania, and Maryland. Our Delaware residents deserve no less. Thank you, Your Honors.
Thank you very much, counsel. We'll take the matter under advisement.
Please rise.